Hello, everybody. How are you all doing today? I am doing so well. I am so excited. Little bit nervous, little bit shaken. One of my all-time favorite YouTubers and probably the YouTube channel I watch the absolute most, Sean Reyes from Long Island Audit, is here. And we also have an additional special guest who is Sean's personal friend and also a lawyer, Corey Zinman. So please do welcome them. Thank y'all very much for coming onto the channel today. We did just do a part one to this little gathering. I don't know, like a little panel. I don't really know. But we did a part one on Sean's channel, Long Island Audit. So if you missed that, you should go back and watch that. If you're here live for it, thank you. And yeah, so what I think we're going to be doing today, which you never know if I'm going to stay on task, but I think what we're going to be doing today is reading through Sean's criminal case documents. The last live I made about this, basically y'all were like, yes, please read the documents line by line, how you do for, the celebrity cases. So here we are to do it all together. And we have an additional lawyer here to add more insights. And yeah, Sean, welcome. Did I miss anything in your introduction you would like to add?
No, thank you. Very kind of you. Very kind introduction. I'm recently a big fan of your channel as well. You do good work, and I really appreciate you having me on.
Thank you. Corey, what makes you excited? And introduce yourself. I don't know, say something exciting. I mean, half the people here probably already know from, earlier, but I'm just actually meeting you today. It's really nice to meet you. I think we're pretty like-minded based on what I could tell so far. Anything you would like to say? Introductions?
I live in Palm Beach, Florida. I'm excited to be here with two constitutionally minded people. That is especially rare in our profession. So,
Sure, isn't it? I didn't know. See, I just passed I just graduated law school in 2020, and I had all these ideas about like what lawyers are supposed to be like, and so I like went out into the world and was like that, like how I thought we were supposed to be, and then I realized like there's really like not many of us doing that. But yeah, thank you too for your commitment to the United States Constitution as well. So I'm looking forward to your help, your insight as well into these documents. So I guess, without further ado, we should probably just get into it. I do want to remind everyone here, Sean was arrested for eavesdropping is essentially what, they said. So let's just remind ourselves, this was the statute right here that was posted on signs all around the Berwyn City Hall where Sean was arrested. And it was clear almost immediately, right? Like by the time they had gotten you, Sean, to the police station, they already said it was determined that it didn't actually apply to him. And then what they did was, instead of admitting they had made a mistake, they went ahead and said, just kidding. We're going to charge you with disorderly conduct. And so that, from what I understand, right, is what you're facing right now as a criminal charge. Is that correct?
Yeah, so I'm being charged with disorderly conduct. I was originally arrested for felony eavesdropping. And like you said, instead of saying sorry and, moving on, maybe I wouldn't even file a lawsuit if they would have publicly apologized, a good learning lesson. It could have saved them a lawsuit, could have saved them bad publicity, but instead they doubled down and just charged me with disorderly conduct, which I like to call on my channel contempt of cop.
Yes. Oh, so you're the person that came from. I've started calling it that as of yesterday.
Great.
As well.
That's what it is. It's contempt of cop. It's basically what you get charged with when you don't bow down to a tyrant police officer.
Mm-hmm. It used to be like just like loitering, right? Was like a law like that, where it's like, oh, you're just standing around in public. That's a crime. Get off of this corner. Like, okay.
I believe my lawyer was telling me yesterday that it's a Class C misdemeanor, so it's like the lowest of, that's it's right above a violation, which is violation of law like speeding, and it's like the lowest crime that you can get in the state of Illinois. I think it carries a max sentence of 30 days in jail. So.
But still 30 days in jail? Like what? Oh, man.
For nothing, I know.
So let me show everyone your website and then how, if they would like to find these documents, they can do so as well. So you'll go to the news and documents tab up here at the top, and then it says documents from Long Island Audit. I think they're at the bottom, right? New. Okay, motion to dismiss. We're not going to that one yet, right? We're going to Oh God, where is it? Oh, here it is. Complaint, right? That's where you want to go first?
Yeah. Yeah. We covered the complaint, but we could do it on your channel too. Yeah.
We covered the complaint. In case y'all missed it, it's very poorly and sloppily written. The cop couldn't even figure out how to use the spell check. We're talking about allowed. We discussed on Sean's channel that even though he misspelled words, it's probably still like, the judge knew what they meant. They're not going to make a big deal about it. And then there's this discovery package as well. And then so Sean files this motion to dismiss, right? Like that's your next document in the case.
Yeah, correct.
Okay, let's see. Just get a sense of, so it's okay, cool. All right. Well, hope y'all got y'all's coffee and y'all's water because we're gonna go through this. But I have time. This is my plans. So, all right. So what I usually do is read this line by line. Let's see. Reading. Okay. So proceeding pro se respectfully moves this court to dismiss the complaint that was filed against you in this matter. And why do you want to dismiss the complaint? Because your argument was they failed to actually state an offense, right? They said some weird things, and that's where is it in the state's response that we're going to see what they said you were doing, like get their insights, or was there a more specific complaint before this?
When we went over the narrative by the police officers, where they basically said, remember with the two different witnesses,
right? So let's just remind everyone of that since we're here now. Okay. It's in your discovery stuff, right? Right here?
Discovery, yeah.
Okay, so the same complaint, right? Again?
Yeah. So
okay.
That's just the complaint that says that I used a recording device to record without people's permission, and thus that caused an alarm.
Okay, so walk us through this. We already covered this, right? That the complaint, we have this person who signed it here, Ruth Siaba Green, who, as we just discussed, is married to what's his title as of right now?
A division commander, I believe, right below police chief and deputy chief.
So he keeps getting promotions, but he's been accused of like 5 different felonies, I think, something crazy, attacking people, being racist, all kind of things. And he just keeps on getting promoted. And so this is his wife here signing, same town. They, of course, work as government officials in the same town, coming as a surprise to not me. Okay, so what are we looking at here? Sean, Berwyn Police Department, what is this? Official sworn police report?
Yeah. So that's the official sworn police report. And then if you just quote, it's written by the Sergeant Volantes, Richard Volante. And if you go down, you should see the narrative.
Okay, and we'll just look at the narrative. So basically, this is what the cops are going to say happened. And we already read this. We're not going to read this line by line. If you want to see that, please do go back to Sean's video we just did. But essentially, this is their story, right? Hold on. I don't know why it's blue like that. Okay. This is their story, right? Like on November 8th, a supervisor was requested. He showed up, didn't know the law. That's not what this says. I'm just giving y'all the gist. And then, okay. So this is basically what you base your motion to dismiss off of, correct?
Correct. Yeah, because these are the allegations that, these are the facts. And when we get, I would like to, when we get into the judge's ruling and what the judge decided to do on my motion to dismiss, it's really important because the judge wanted the facts, and these are the facts of what happened. So she's already privy to the facts.
Yeah, it's I'm mad about what the judge said, but okay. So now we got our little context situation. All right. So Corey, about to tag you in. Let me see. Got to find where I am again. Doing stuff live stresses me out, Discovery documents, motion dismissed. Okay. All right. The people. Imagine, even just looking at this, what feelings cross through your heart when you see that? I am infuriated.
Disgusted that they use the people as like the people want this, because I can tell you that this is not what the people aren't against me. They're with me.
The people comment below. Are you trying to sue? Are you hoping your tax dollars get used to sue Sean? Yes or no? I say no. I vote no. Okay. For something he didn't do. Okay. So walk us through, Corey, what are we looking at here? Defendant's motion to dismiss. What does it mean to fail to state to fail to state an offense? What would that mean for a case in general?
From what I understand, just reading Sean's motion, it's not that he's arguing that he didn't do what he's been accused of doing. It's that he's arguing that what he's accused of doing doesn't constitute the crime that he's been charged with.
Right. They don't like, they just describe some actions and then go, and that's a crime. Like, oh, Sean was minding his business, you know, and some lady got alarmed, which is clearly false, but let's pretend it was. And they're trying to extrapolate that into being a crime. That's kind of what seems to be the underlying argument we're going to see here.
Yes, they're taking a constitutionally protected activity and turning it into a crime.
Yeah, because from, you know, when I wrote this, and I'm sure Corey, when, you know, when you're filing a motion to dismiss, there has to be a ground, right? You can't just say, it has to be a legal ground. Like, you can't just say, I want to dismiss this because they're turning a constitutionally protected activity into a crime. Like, or this is stupid. So, you know, Illinois, every state is different. So Illinois, there's like, I think you can speak better to this, but I'm sure there's like different states, like different type of subjects you can file a motion to dismiss under. And I think stating an offense, it fails to state an offense, is one of them. Correct, Corey?
That would be correct. It's either, you know, it's either jurisdiction or, you know, failure to state an offense is pretty typical.
Gotcha.
So Corey is actually Sean's friend, and also he is a lawyer who is licensed in, I believe, Florida and perhaps other places. But he's also just here to comment on this case because he actually knows about it, right? He's been following it and he knows about it, you know, probably more than me because he's been, you know, personally friends with Sean. So that's Corey. He's a new friend that we now have to the channel. Okay, so what are we looking at? Okay, so as y'all know, you do the motion first, and then you write a little memo, a memorandum, to basically support why the fuller, fleshed out legal argument of why you want it to be done, what you had said in your motion that you made. Okay, so we have Sean submitting, you know, okay. So Sean says, Mr. Reyes is an independent journalist who travels the country recording public officials for the purpose of promoting government transparency with the public. On November 8th, you entered into the municipal building. So you just kind of say like what happens with Ruth Siaba Green. There's this altercation. She inserts herself, right? I should have uploaded the video to show here, but y'all saw it on part one, and you also saw it on my last live. You know, Sean's just really minding his business. You're talking, you know, at a very low voice. You walk by Ruth's office and she kind of yells out to you like, can I help you or something, right?
Yeah, exactly.
And so this just describes that whole incident, right? And then Sergeant Volante shows up, who's supposed to be the person who, if God forbid, nobody else knows the law, at least he's supposed to. He shows up, white shirt and all, talking about you can't video record private conversations, which, like, I guess, you know what, technically speaking is true. But why don't we look a little bit at the statute just real quick, right? Because this was the eavesdropping statute. What it says is, for the purposes of this article, the term conversation, right, for private conversation, means any oral communication between two or more people, regardless of whether one or more of the parties intended their communication to be of a private nature. But look at what this says. And Corey, you brought this up on the part one. This statute, the eavesdropping statute in Illinois, says the only time a private conversation can even be private is if there is an expectation of privacy, right? Circumstances would need to justify her expectation. So Corey and also Sean, do y'all think it is reasonable for Ruth to expect with her door wide eyes open? I know, Sean, that you did not record her, right? But let's pretend you did. Do y'all think it's reasonable for her to have, is it a reasonable expectation of privacy? Corey?
I mean, just being in public, no, that's pretty well established that you don't have an expectation of privacy in public. But I think the more pertinent part here is that Sean was already recording before he was engaged in, he wasn't surreptitiously recording a conversation. He was recording, and then she happened to approach him.
Right. And even if Sean had, you know, been sneaky about it, he didn't catch any conversation on his phone, as far as I could tell from the footage. So there's many reasons why this statute just can't apply. And that's why they switched to disorderly conduct. So let's see what else is going to be said. So far, yeah, you're just telling what happened. And it's all, you know, it's obvious. Y'all can go fact check this yourself because all this whole interaction is recorded and uploaded and has several, probably 100,000 views at this point. Okay, so the sergeant shows up, says you can't record things. Essentially, you get arrested on the eavesdropping statute. Once you get to jail, they realize they can't charge you with that. They change it to disorderly conduct. And so this is your argument. A person commits disorderly conduct when he knowingly does any act in such unreasonable manner as to alarm or disturb another and to provoke a breach of the peace. So what is their argument, Corey or Sean? How are they trying to say that your behavior fits under this statute?
Well, I think
It seems that they tried to go ahead.
I just think that what they're trying to do is they're trying to say that it's unreasonable for me to record people when they tell me to stop recording them. I think that's the whole argument.
And they were alarmed and disturbed.
Alarmed, yeah, you have to be alarmed and disturbed, exactly. And when we just watched the video on my channel in the previous live we just did, she didn't even look alarmed or disturbed. Like, she looked completely fine, and I can't wait. The good thing about a trial and not going to trial is she has to go and testify, and I can't wait to have her on the stand under oath to expose her. But
yeah, I can't wait either. Go ahead, Corey.
They clearly drafted the complaint intending to charge him with eavesdropping, and then when they realized that wasn't applicable, they kept the complaint that they had already drafted and then added causing an alarm or something like that, like at the end of it.
And Corey, I wanted to ask you too, when I was reading through this, it seemed sort of impossible that something could be both a First Amendment protected activity and also a breach of the peace. Do you have any insight? Does that strike you as something odd? Like, how can something that is a well-established constitutional or First Amendment right in particular breach the peace?
I mean, I wouldn't go as far to say that like any First Amendment protected activity couldn't constitute a breach of the peace. I mean, I think that if Sean was in there protesting or something like that, or, I mean, even that wouldn't, but if he somehow did that with the intent to alarm others, then I guess that could be, but under these circumstances where you're just recording and minding your own business, then, obviously not.
Yeah. Have you seen have you seen or noticed a trend toward, this type of charge where, if they can't get you on the first thing, they just charge you with anything to try to make you plea out to something? Or do you have any experience in this area?
I mean, I've never personally in my own personal experience. I mean, like if it was maybe like, a difference in a manslaughter and a murder charge, I could see that, but I don't understand how you accuse somebody of doing something surreptitiously, and then in the next hand you're saying that they're going out of their way to, like, which is it? Are you being sneaky, or are you purposely causing an alarm?
That is a great point. And I think you mentioned this elsewhere, I think, but I hadn't thought of that, right? It's kind of like when they couldn't get Sean on eavesdropping, which if you really think about it, like eavesdropping just sounds like something that's sneaky, like you're trying to record people's private. When they couldn't get him on that, they completely switched and was like, he was making such a huge ass scene. We had to bring him to the jailhouse. It was the biggest scene you ever saw. He had to go to jail. But the reason he got driven to the jail was because he was sneaky.
I mean, they take these vaguely written statutes and then they try to, make it applicable to whatever facts that they have. I mean, you mentioned it before with loitering, and, here we have disorderly conduct. Breach of the peace is another one that's similar.
Yeah. What, like purposely causing an alarm by not being sneaky? Okay. So the committee comment states the types of conduct intimidated. One enumerated example of such conduct is indirectly threatening bodily harm, which may not amount to assault. So basically you're using examples of like where this law could apply, right? Like you're saying, okay, like here's where that applies. It's whenever people are threatening harm, or let's see, the conduct is dependent on the circumstances. Disorderly conduct is loosely defined as a highly fact specific inquiry. See, and this is what the judge is going to come back and say, right? They're going to kind of try and hold this part against you. You want to speak on that, Sean, just to give us a little bit of a preview?
For sure. Yeah, no, for sure. This is the language that the judge is relying on, that it's disorderly conduct is a highly fact-specific inquiry. So, it depends on the facts. But my counter argument to that would be, if I was able to give one while the judge, after she made her ruling, which you can't, but the facts are already here. The facts are in the complaint. The facts are in the narrative, and none of the facts of this case would state an offense, which is what the motion was filed under, not stating an offense. So if it didn't state an offense, it should be dismissed. She made the argument that, again, a little bit ahead, but she made the argument that, I don't know what she's going to say. I don't know what the witnesses are going to say. I don't know what Mr. Reyes is going to say. You do know what we're all saying, because it's all in the narrative here. It's all in the. Do you think that if I were, for example, filming somebody could be considered disorderly conduct, in my opinion, if you're doing other things with it? Like, say you're holding your camera an inch away from somebody's face, right? Or I would consider that, disorderly conduct, because you're trying to put it right in their face. You're going in their personal space. You're trying to gauge reaction, or you're following somebody for, that could be, that would probably be stalking if you're doing it, multiple times. But again, the whole thing is you're in public, so there's really no expectation of any kind of privacy in public, which that's why this whole thing is like really absurd. But I don't know. I don't know how anything could. What can Ruth Siaba Green say that would be a fact that would lend to me being disorderly? You know what I mean? So I don't understand. I get, I did put in the motion highly fact specific inquiry, but the facts are there. The facts are there, and the video is there. So,
and I think also, as Corey said, the facts that they did put into the complaint don't really describe a crime. I mean, they didn't really state a claim that they could really prove anything on, even if they had all the facts, because they're not even if what they're saying is true, that's not a crime. So it's a highly fact specific inquiry, which is, true, but the facts are, I mean, I agree. I guess I like to go on the both sides counter argument thing just for the sake of it. I guess the judge could say, I'm not supposed to have watched your videos. I'm not supposed to have, by rules, she's not supposed to know anything outside of what is presented to her by, one of the two parties in the appropriate way. So I guess she could, that's one possible, if I have to say, maybe, I don't know, just a counter argument, maybe that's a little bit playing into it, but I have seen the video. And so it just makes it so infuriating that they're still even proceeding with these charges. And I'm almost more upset with the county or the city or whoever it was that actually pressed these charges and is filing. What's the state's attorney, Alyssa Dunbar, right? I'm kind of more infuriated with them, because at any moment they can snap their fingers and take it away from this judge to even have to decide. And they still haven't. Do you have any opinions on that? You disagree or what?
Yeah, I think Corey could do a better job at explaining. When the prosecutors get when they get a case, they don't have to take every case. I believe that it's a null pros, right, Corey? They can decline to prosecute the case, which they do all the time. And in fact, this specific state's attorney declined to prosecute, not Alyssa Dunbar specifically, but the office, Kim Fox's office, declined to prosecute, for example, Jussie Smollett's case.
Same office, huh?
Same exact office. So they declined to prosecute Jussie Smollett's case. And we all saw what happened with that, and how the judge appointed a special prosecutor in that case because he thought that there was, something that should have been prosecuted. But, for something as serious as that, what he was allegedly doing, or he was convicted now of doing, they can let that go and say, oh, we're going to null pros it. But, for my case, we're doubling down on everything. Like you said, the judge shouldn't have seen my video, whether she's seen it or not, who knows, but she shouldn't have watched it. But who can watch it? The state's attorney's office. And, who did watch it is the state's attorney's office, Alyssa Dunbar, because every time we're in court, she brings up the fact that I'm talking about the case and tries to get me in trouble with the judge. And the judge tries to say that I can get in trouble one day for posting discovery documents. The same documents we're discussing right here. The judge is trying to say that, if I post them, I can get in trouble someday somehow, trying to threaten me. But I don't back down, so I'm not scared.
Good. Me neither. I'm just like you, which leads me to this comment. So Chris is saying, do not blame the junior prosecutor. And I have something to say about this, Chris. I understand your position, like why we shouldn't take things out on the lowest level person and like a conspiracy. And I can understand where that comes from, but here's the issue. Most of the time, the harm that is being perpetuated on we the people is not by the main head person in charge. It's by a bunch of minions who aren't taking their oath to the Constitution seriously. So when I was working at Winston and Strawn as a second month on the job lawyer, third month on the job lawyer, and Lou Taylor came to my law firm and she made me have to face the decision to stay at the law firm and participate in a corrupt and unethical system or leave and risk my paycheck and risk all that stuff. I had to make that choice. I was only an attorney for less time than Alyssa Dunbar has been an attorney when I had to make the choice to do the right thing. And I did. And if that meant going out on the street and sleeping and having to be on welfare, then so be it. Because I took an oath to the Constitution and I have ethical principles. So I will be blaming the junior prosecutor because she had the same exact decision to make that I did. She could have said, this is bullshit. Y'all are all on a next level bullshit. I don't know what happened to you between the time you graduated law school and right now, but something really weird must have hijacked your brain because this is not what we promised to do. And I was just working as a private attorney. So I will be blaming the junior prosecutor because she at any moment can go to her superiors and say, I'm not putting my integrity on the line for you. You file this case. You're wrong. I just took the bar exam, however many, 2, 3, 5 years ago. And I know for a fact that he can record in public and I'm not putting my reputation out here on the line for you people. That's what she should have said. And so I'll get off my soapbox, but that's my opinion on it. I think it's fine to blame the junior prosecutor because we have to stop somewhere. She's the one charging. If you go to jail, it's going to be her fault. So why can't we blame her? She's blaming you.
Exactly. No, I agree. I think that's a great point. I think that's a perfect point because you left your law firm for your principles, and she can make the decision whether to prosecute the case or not. She doesn't have to prosecute it. She can put it. It's going to be on her. I don't know any of the state's attorneys' names. The only state's attorney's name that I know is Alyssa Dunbar. So whoever's pulling the strings, it doesn't matter. Alyssa's putting her name on this prosecution, and she's doing that willingly because she could do what you did and stand up for her morals and principles and just leave the state's attorney's office, go get a different job, go work in private practice, go be a public defender. I don't know, but
be a whistleblower, girl. Come on my channel. I will let you talk.
Exactly.
I just want to say what you just said just literally gave me chills because I feel that to my core. We took that oath, and that means everything to me. But obviously, it doesn't mean squat to the vast majority of people in this profession, which is really sad. Honestly, I wonder why we even are still required to take that oath when the vast majority of attorneys out there, that's first and foremost, that's what you swore to do, was to swear, to protect the Constitution, defend the Constitution.
And I took it seriously. I thought that was you putting your hand on something really important and swearing that you're going to do something as the pinnacle moment of your education that you spent 20 to 30 years getting. And then just like 2 years later, you're going to like grind it into the dust and dance on its grave. I don't understand. And so, no, yes, we can blame the junior prosecutor and it looks like we will. Okay, good. Glad we're all on the same page on that. Okay. Let me see.
It's definitely not unique to her.
No, we're unique.
Yeah.
Okay.
Get on the right side of the Constitution, Alyssa. Do the right thing.
Do the right thing, Alyssa. You want to whistleblow? You can have a platform. There must be at least some relationship between the accused conduct and the public order, or between the conduct and the right of others not to be harmed. Okay, where was I? So this section is basically the motion should be granted because here's the statute, and then here's you're giving examples of how the statute has been applied in the past, right?
Correct. Yeah.
The complaint signed by Ruth Siaba Green, who is the city administrator, is not sufficient to charge Sean with the offense of disorderly conduct. Okay, so that's the conclusion sentence there. To be convicted of disorderly conduct, which can be committed in a variety of ways, a charging instrument merely in the language of the statute is insufficient. So what you're arguing here is just because you use the words from the statute, that's not enough, right? And that was decided in People versus Bergeson. Corey, could you describe a little bit like what this actually means?
He should be able to.
I mean, it's like
he showed.
It's like what I was. Go ahead.
He should be able to, because he definitely gave me this. He showed me this case law. He sent me the case law when I was writing this motion, so he's very well familiar with it.
Anyway, yeah, it's like what I was saying. They clearly drafted the complaint intending him to prosecute him for eavesdropping, and then they add a little comma, causing an alarm to employees or whatever. Like, that's merely in the language of the statute. You're not saying how he knowingly, went out of his way to cause an alarm. You're saying that he was doing something that happened to alarm other people, but he has no control of. It's got to be objectively unreasonable.
So when this goes to trial, Corey, will there be arguments or, what will the state have to do on that knowingly part of the statute? And could you explain the importance of the knowingly?
I mean, the state definitely carries the burden to prove every element of the offense, including the knowingly aspect. I don't see how they could do that. But I mean, the motion to dismiss has already been denied, and it sounds like Sean's going to a bench trial. So the same judge will most likely be hearing, the trial, or I don't know how it works in Illinois. But if that's the case, then I would expect, if the judge wasn't willing to dismiss it based on this motion, then I'm not sure, what it's going to take. So I hope I'm wrong, but it might have to go up to appeal.
Do we have a trial date set for this case?
So the next court hearing is June 8th, and that's when we'll be setting a trial date. And I spoke to my lawyer, and he told me that we should be getting a trial date probably in July. I would say a trial, and to clarify, Corey's concern is that it might not be the same judge. They rotate, so
okay,
it can be a different judge or it can be her that does the trial, or. And again, I'm not so sure that she wouldn't, because again, you're putting no judge likes to be overturned, their rulings overturned, or they're not going to want to put their name on something, especially something as highly publicized as this case, on something that says just basically that freedom of press can be disorderly just because somebody feels alarmed. My counter to that would be, people do that all the time. That's in journalism. People you see it all the time. Reporters go to judges' houses, public officials' houses. They wait for them to come outside and they pepper them with questions and they follow them and hey, can you do you have any comment on this and that? And then it's a slippery slope, because now what they're saying, what the state's attorney's saying, Alyssa Dunbar, is saying that just if they do that and ask me questions and record me in public, I can just say that I'm alarmed, call the police, and have the journalist arrested at any time that I want, just because I'm alarmed by their camera and their questions.
And I'm alarmed by that notion, even. Exactly. I'm alarmed by that.
I think
somebody charge him.
I think Alyssa Dunbar should be charged with disorderly conduct. I'm alarmed.
I'm alarmed. Are y'all alarmed? We should do a class action. Everybody, let's get together and class action Alyssa Dunbar, because we are alarmed and disturbed by her disorderly conduct.
100%.
I like this comment, and I thought the same thing. Quinn says, I bet everyone just followed that sign up until you, right? They could have put up any damn sign they wanted to. And I said that in my last live. What if the sign on the door had said, no women allowed, or no gay people, or no veterans? Would Monaco would have said, no woman, you got to get out of here? Probably not, because that's like a little more absurd for the average person. But like, that's what's going on here, right? They just put up a sign. It didn't apply at all, as for many reasons. And people probably did follow it. They just lied to we the people. Nobody checks them on it, and we lose rights more and more each day because of that. Okay.
Absolutely.
Let's get back to the task at hand, as it were. All right. So then you go on to say an arrest and conviction for disorderly conduct is justified only when the defendant directly bothers or harasses other people, or when. It doesn't say only. Conversely, right, on the other hand, vulgar language, however distasteful, so saying curse words, does not evolve into a crime because people standing nearby stop, look, and listen. Okay, so this is really important, okay? There is case law on point that says even if you're standing there cussing up a storm and the Karen standing next to you is very upset about it, that does not count, right? A court has had to determine this already, and they done said that don't count, okay? So just close your ears or move away because people can cuss in the public, okay? So you've cited that. So it's interesting to compare what we saw. It's so interesting. The whole thing is on camera, probably two angles, right?
Yep.
You're not doing anything even close to this, and you're being charged under this statute.
Exactly.
And this is protected. Look, vulgar language, even if it's distasteful and offensive to somebody, doesn't evolve into a crime. But you just quickly walking past Ruth Siaba Green's office is a crime. But
calling her ma'am, speaking to her with respect. I was better off cursing her out at this point.
And that's why I said in my live, I don't think I could do what you do. And then I amended it to like, if you were there, I could, because I would know you would do the right thing. But like, I see some auditors and I'm like, if I was there with them, we probably would get arrested for disorderly conduct because we would just be like hyping each other up. And like how you stay calm. I constantly, Corey, are you a calm person? Like when you're watching these videos, does your like heart race? Like, oh, it just makes me so nervous whenever the cops are acting like that.
Yeah, that's how I reached out to Sean in the first place. I was just a fan of his, a follower, and that's honestly why I like Sean so much, because I watch a lot of different auditors, and his style is definitely the most effective for actually having an opportunity to make case law. Because if you're out there acting a fool, you probably will be charged with disorderly conduct and convicted, and you're not advancing the cause.
Right. There's some things that, we have the right to do, but it's kind of like can be considered so distasteful that you're kind of hurting the cause, right? Because I see people, the bootlickers, come after Sean and say, you're just trying to get a rise out of people, or you're just trying to and they're almost kind of holding Sean accountable for like what other auditors are doing. And I think it's really unfair because I haven't seen it really a lot. I haven't watched a lot of auditing videos. I might have watched, maybe 5 channels or whatever. But yeah, it just stresses me out though. So I understand why people are like confrontational with the cops, because in their mind, they know that it's wrong what the cops are doing and they're trying to set it right. But like you said, Corey, there's effective ways to do it. And then there's kind of ineffective ways that don't move the needle for us. And that's our point, right?
Mm-hmm.
Okay. So you could cuss by somebody and that's not against the law, but walking by an office apparently is, I guess. All right. While it is true that an argument per se is not disorderly conduct, whether a violation has occurred is determined by the reasonableness of the conduct in relation to the surrounding circumstances. So this was a case that addressed, kind of getting to an argument in public. Is that disorderly conduct or not? The court said, it has to be case by case, right? But it's really going to come down to whether it was reasonable, the whole entire thing, right? So a judge is going to have to look at the case and see whether it was reasonable. Okay. Now you include, I think, very important, arguing with a police officer, even if done loudly. Me, look, hold on. Y'all take a screenshot because this is the one I'm relying on when I go to this court case. Arguing with a police officer, even if you hollering, is not disorderly conduct. Okay. Y'all see that? That was decided. Oh shoot. Is this Bradshaw? The state's concern becomes dominant only when a breach of the peace is provoked by the language. What is a breach of the peace to your understanding, Corey? Because it's kind of like elusive and vague to me what it even means.
That's the point. A breach of it's, it is what, whatever they say it is until the, appellate court says it's not. And then that's. That's pretty
So,
vague, though. You're right.
I mean, it's scary though, as a person with disabilities. I mean, is a breach of the peace an actual crime with elements, or is it just a thing they
Yeah.
just say?
I think he's been charged with disorderly conduct, but it's the same thing. I mean, I think they use breach of the peace in the disorderly conduct statute.
Okay.
Um, and yeah, that's as vague as it gets. What is a breach of the peace? What is a breach of the peace to one person isn't necessarily breach of the peace to all people. So that's why I think in this case law they keep harping on the reasonableness, and I would imagine that's an objective, reasonable standard.
And it's very slippery too. Like when you're in law school, or really even if you just read a lot about the law, you keep running into this reasonable person standard, right? And it's kind of starting to be a little scary to me that like enough people think that like certain protected activities are unreasonable. Like, for example, when people say, I don't want to tell a police officer my name, right? I'm not using that because it's like that's not a reasonable standard. That's crim pro. But I guess what I'm concerned about, I guess, is the slippery slope of these vague, like elementless things that didn't just get used against us at direct opposition to our rights, like our very important ones, like free speech and freedom
Well,
of assembly.
on your example, it is a bit of a reasonable standard because the officer would have to have a reasonable, articulable suspicion that
True.
they have engaged in a crime. So it's I totally agree with you. You shouldn't forfeit your rights, and the more people that continue to do that, you know, it's you're setting a precedent in the wrong direction.
Yes. Yeah. That's kind of my concern. I'm like, y'all, we got to start using our rights a little. And I think, Sean, you understand that, before you definitely understood it before me, right? I realize now that people don't use their rights. And then as a result, we're going to lose them if we don't use them. I mean, people say that on your channel a lot, I think.
Yep,
Okay.
for sure.
So, moreover, the offense of disorderly conduct is not. So, y'all, this is something, again, just to remind y'all, this is Sean's argument, right? The offense of disorderly conduct is not intended as a catch-all for every act that annoys or disturbs people. Ruth Siaba Green. It is not to be used as a dragnet for all irritations which breed in the ferment of a community. So the translation here is just because you're annoyed and disturbed. Look, was she alarmed and disturbed, or was she annoyed and disturbed, Sean?
I don't know. I think she was just annoyed. I don't think she
So
was alarmed at all. She's probably just she was annoyed, but again, it doesn't come back. We're not. I tell the police this all the time. You're not feelings police.
yes.
So, Alyssa, you're not feelings prosecutor. Okay, you're not prosecuting somebody. Like I said, I feel annoyed that Ruth is doing this to me. Does that mean that she's committing disorderly conduct? No. Like it's not a one catch all. It's not a one catch all crime. You can't just feel something and then the other person is automatically guilty of disorderly conduct.
Right. And that's what this case says. Commonwealth versus Hawk. The offense of disorderly conduct is not a catch-all just for something that annoys and disturbs people. But I think it's interesting that the court determined annoys and disturbs specifically. Now, this does look like a case from Pennsylvania, which, maybe the judge could say it's not applicable in this jurisdiction because that's not the same statute. But they use the word disturb. So even if you're disturbed, you still have to be alarmed and disturbed. Just annoying you, even if you are disturbed, is not enough for disorderly conduct, is what I'm reading here. Again, there's this Pennsylvania distinction they might bring up, but I do think it's important. It's not supposed to be some catch-all for just you're annoyed, you're aggravated. And that's what this case says, and that's what Sean tells people. You're not feelings police. You're not annoying police. You're law enforcement. So unless you're here to enforce a law, get out of my face. He's much nicer than me, as I've mentioned. Okay. A city cannot threaten to prosecute protesters. Okay, so now we're talking about protesters, another First Amendment protected activity. If such threats are nothing more than a pretext for stopping unpopular yet protected speech. Again, another case law that supports what you were doing. It has a specific purpose. Disorderly conduct statutes have a specific purpose, a definite objective. What is the intention? To preserve the public peace. Well, it seemed very peaceful until Ruth Siaba Green inserted herself into what you were doing, and you're conducting your business at the city hall. Do you have anything to add on that one?
Yeah, I mean, everywhere I go, it's always peaceful until the public servants, and the public officials that work there they always tell me you're creating a disturbance. I got a video coming out tomorrow that he's like, you're creating a disturbance. I'm not creating a disturbance. I'm not. I don't follow people around. I don't film people specifically to annoy them. I'm filming the building. I'm filming in publicly accessible areas. If you ask me what I'm doing, I'll tell you I'm an independent journalist. If you tell me your name and you're respectful towards me, I'll even tell you my first name. Done it plenty of times. Watch my videos. But it's more of the fact that they're trying to make other people. I can't go up to somebody and say, you're creating a disturbance here when I'm the one creating a disturbance. Like, it doesn't make any sense. Everything was peaceful until Ruth and the police with guns showed up. Everything was peaceful.
Everything was peaceful until Ruth and weapons got involved, as far as I could tell as well.
Exactly. For sure.
Okay. What else is going on here? Okay. It is limited in its periphery beyond which the prosecuting authorities have no right to transgress any more than the alleged criminal has the right to operate within clearly outlined circumference. Okay. Agreed. The Supreme Court of Illinois noted in People versus Davis, and in this 1980 Supreme Court Illinois case, the offense of disorderly conduct is intended to guard against an invasion of the right of others not to be molested, and that means a specific legal word, right? Or harassed either mentally or physically without justification. Okay. So
that's the key there, is without justification.
Go ahead, Corey.
Because, if you're engaging in a constantly protected activity, isn't that, you're just, there's, I think, more case law coming up when you're in a place where you have a right to be, doing something you have a right to do. That's justified.
Right. That's what I think. And then there's this other part too. The right of others not to be molested or harassed. Well, come on. You didn't even flash the camera in Ruth Siaba Green's direction. And another thing that I noticed about the complaint, Sean, is that it says you were filming private conversations between public officials and Berwyn residents, but who was in that office was a Monaco or whatever his name is.
I didn't notice any private citizens there. Again, and you have to create the onus, just like people bring up HIPAA all the time. If I'm in a healthcare facility or whatever, I don't really go to healthcare facilities, but say like I'm in a town hall, they're doing vaccines and they're doing it right there in the public lobby. They're like, you can't film in here, HIPAA, right? So they say, you can't film in here, HIPAA, right? Which is like the privacy for that HIPAA applies to healthcare workers, insurance companies, like doctors, etc. It doesn't apply to the public. So that goes on. You have to create your own privacy. So if Ruth didn't want anybody hearing her conversation, her thing is she would have to close the door, try and create some kind of privacy. She has to create, the onus is on her to create the privacy in a public setting, or even in a private setting. She has to keep the onus is on her to keep her conversations private. And there was nobody even there. And it doesn't matter if you're a citizen or a public official. They're trying to say that, customers or, private Berwyn residents that aren't public officials. No one has an expectation of privacy in public. Whether it's, a citizen like me, I don't have one either. You know how many people take out cameras and take pictures of me while I'm doing an audit? I just smile. Like, it's not a big deal. Go ahead, take my picture if you want to. It's not that big of a deal.
Especially not a public servant, though.
Yeah, no, especially not a public servant, but no one has an expectation of privacy in public.
Wasn't there one private citizen who, I think it was, I might be confusing this incident with another, but I feel like it was on the stairs. And then they asked the private citizen, like, sir, do you want to be recorded or something like that? And the citizen was like, I don't mind. Right?
Yeah. Like, leave me out of this, you psycho. Yeah. Like,
so the sergeant Volante, the white shirt, he actually, this was that incident. And it's so funny that I never showed that on my, it's in the video, but I never highlighted it. But it was so funny because he's like, sir, do you want, as he's leaving, he's like, sir, do you want to be recorded? And he's like, I don't care. And he just walks away. Like, I think that'll be great evidence in court. Because he's just like, I don't care. Like, what do you, like, I don't care. Like, it totally backfired on him. Totally. But even if he would have said, I do care, it doesn't matter.
It doesn't matter. I've seen that somewhere else too. In one of your videos, it had to be, where it was like, whoa, it was in that post office when that postmaster, and he was like, ma'am, he's recording. Make sure you cover up any private info in case you don't want to be, he's record. like, sir, you're the one disturbing the peace at this point. That wasn't this case. It was like a different one, right? But
He actually,
why
that postmaster actually held up he was so childish. I remember all these specifically. It was in New Jersey, actually. And he held up, I believe, Glassboro. And he held up somebody's mail to my camera and is like, see, you're getting private information. Like, are you insane?
Yes, he is.
Are you insane? You are the postmaster in charge of securing these people's private information, and you're holding it up so I can get it on my camera, like so that way you can blame me in his head, so that way I can be at fault. That goes back to saying that these people create the disturbance. They do not keep their documents private, yet they want to blame me for everything.
And you know what else?
I'm gonna have to
Like,
step away for 1 second. I'll be right.
sure. Another thing that I notice is like all these people have all this concern about privacy until they need to tell your business. Then all of a sudden they don't care about your privacy. Like all those police like Facebook pages that like put suspects pictures out before they're proven guilty, all this stuff like y'all like has schizophrenia. Like, excuse me, y'all are not worried about people's privacy then, but you're worried about people's privacy when I'm trying to hold you accountable in my taxpayer funded facility. I don't know. It does not add up to me. Okay, so now you're describing this other case in which a defendant was convicted of disorderly conduct after allegedly entering the home of an 80-year-old wheelchair-bound woman, pointing his finger at her, saying that his brother was not going to jail or to court, and reversing the trial court's conviction of the defendant. So that defendant was convicted for disorderly conduct, and then that decision was reversed, so they got unconvicted, basically, as far as it's not the official word, but that's for understanding purposes. The appeals court said the defendant's acts did not constitute disorderly conduct as a matter of law. However, again, the Supreme Court reversed it back again. I guess he got convicted again and affirmed that conviction. In doing so, this is what the court said. In effect, the court noted that the defendant had, in effect, told her that the charge against his brother should not be prosecuted or some undefined threat would be carried out. So she kind of threatened, right? Like, something about a prosecutor, if you don't do something, then I'm going to, and XYZ. There was a threat, right? So in an effort to charge against such conduct, according to the court, falls squarely within the type of conduct. Okay, so what you're doing now is basically saying, okay, here's all the things that the court has said is not disorderly conduct, right? Arguing with a police officer, not disorderly conduct. Cussing out loud, even if you're hollering, not disorderly conduct. All this stuff, not disorderly conduct. But if you bust into an 81-year-old woman's house screaming and hollering, then yeah, maybe that's disorderly conduct, right? Is that what I'm understanding this correctly?
Yeah, exactly.
Okay. Then we get, go ahead.
It's just different case law just to show what is disorderly conduct, what isn't disorderly conduct. And a lot of people, I wanted to, touch on this a little bit because it's very important. A lot of people say there's limited public forums in, as far as a limited public forum would be like a city hall, a library, things of that nature are limited public forums. A park, a sidewalk, those are traditionally public forums. The court have ruled there's a difference. And a lot of people, bootlickers and wannabe attorneys that wish they had law degrees like you guys, they always want to talk about how limited, and I'm sure you could talk about this too, Corey, is that they always want to talk about that you cannot film in a limited public forum because the courts have ruled that. So my argument to that, and I'm sure Corey could say more on this, but they're misguided, right? So a limited public forum, what the courts have ruled on is that, say in a library, you can't go into a library and protest. Like, you can't go into the library and disrupt everything and start having a protest. You can go into a park and start protesting and say F the police and do whatever you want, like have pigs around and whatever you want to do to protest against the police or against the government. You can do that in a park or on a sidewalk, but you can't do that in a library, which only makes sense, right? The library has an intended purpose and it needs to be able to function for that intended purpose. But what, these bootlickers and wannabe attorneys want to try and make the world, believe is that because they're saying that and again, protesting is part of the First Amendment. So they're saying that because the First Amendment there's restrictions on it, which there is as far as protesting and being loud in the library and stuff like that, that filming, that doesn't, the courts haven't ruled that freedom of press in limited public forums can be restricted. They haven't ruled that. There's an injunction out there that people want to point to in Florida. Sheets is the case law there. Not case law, excuse me, an injunction. But there's no case law pointing that freedom of press activities can be restricted. I don't know if Corey, you want to speak on that.
In fact, there's actually that appellate court decision that I sent you that pretty much said that, like, just because forum analysis is used, that's what we're talking about with the public forum, limited public forum, just because that's used in the context of expressive activities like protesting and other speech related things, that doesn't necessarily apply to like what you're saying to freedom of the press, which is not inherently an expressive activity. Merely recording is not, that's not a speech activity. So therefore forum analysis doesn't even apply.
Yeah, and forum analysis would be, a reasonable time, place, and manner restrictions, right? That's what they talk about. Mm-hmm. Reasonable time, place, and manner. So the way I think about it is recording peacefully without bothering anybody, is that reasonable? Yeah.
Well, and for the purpose of news, right? Like you actually have a platform where you share the things that happen in public buildings. So you are doing it for the people can say all day long that you do it to to get a reaction out of the police. But if that were true, why would you post them on YouTube?
Exactly.
Your intent was to post it on YouTube. Your intent wasn't to get a rise out of people. Like Corey said last time, however you act when the camera's on is your business. I'm not making you do anything just because the camera's here. Maybe you said that, Sean.
Yeah, no. And the reasonable is the restrictions would be for, time, place, and manner. Mm-hmm. So time in for example, we'll use Berwyn as an example. Time, it was I think 1 o'clock in the afternoon when this happened. That's during business hours. They're open. For example, I can't just break into City Hall because it's a public building at 11 o'clock at night and start recording because I have a First Amendment right to do so. Obviously, there's going to be restrictions. Again, time, place, a public place like City Hall, and manner, how you're doing it. You can't just walk around City Hall saying, start screaming at people and start getting in people's face and start acting like a fool, then obviously that's disorderly conduct. So that's what I wanted everybody to know, because there's a lot of bad information out there. There's a lot of channels out there that, spread really bad misinformation about, how there's multiple publics. There's only one public. There's a forum analysis on public, though. And that doesn't apply to freedom of press. There's no case law stating that. So I just want to clear that.
And an outright ban on recording is in no way, shape, or form a time, place, and manner restriction. That's just saying that, it's a prohibition.
Yes.
Exactly.
Correct. Yeah. And like putting those signs out specifically, and then everyone relying on and pointing to those signs is a prohibition, because as soon as I see a camera, oh no, it's illegal. It's illegal to record in here. Oh my God. I think that's the sentence I hate the most. When they tell you it's illegal to record in a federal building, it's like I get like a twitch or something every time I hear that now. Cause it's like, it's been so obviously established that that's not true. And they say it with such confidence. I don't know why it makes me so mad. I got to go to therapy or something, I guess. All right. Okay. Where are we now? We're here, right? Okay. So we're about to go into more case law. We are talking about, in People versus Bradshaw, the appeals court in Illinois, 4th District, reversed a defendant's conviction. Okay. So a defendant was convicted for disorderly conduct, and then the appeals court turned it over. And what'd they say? It noted that unlike People v. Davis, where's that? Did we read Davis?
That was the previous one with the 80-year-old woman.
Perfect. So we got this poor old lady. She's getting cussed out in her house. Man gets charged with disorderly conduct, gets reversed, then it gets convicted, not charged and convicted. Okay. So then we're looking at another case which compares that 81-year-old lady case, which is Davis, right? In that case, it says, unlike the 81-year-old lady thing, in this current case, Bradshaw, the defendant did not threaten anyone. So it's a big deal that there was a threat involved between these two cases. Further says no group gathered around found defendant in a threatening manner. So they would need, there's no group. No one found him to be threatening. So that's it, right? So that case basically says there was some threat involved in the 81-year-old lady case. But remember, this is all fact specific, right? So each case, they're going to go by a case-by-case scenario and determine whether it was disorderly. And they're going to tell you as they go, the courts, like what things they find important. So whether or not that's okay, in your opinion, leave comments below, but that is how it works at the current moment. So they're saying it is important whether or not you threaten someone. And of course, we know applying those facts or these cases to our case here, you did not threaten anyone expressly or even implied, right? You were literally minding your own business, just filming and speaking quietly while Ruth Ciaba Green inserted herself into your news and content gathering. Okay, so then we have this other case. Defendant's conduct was nothing more than annoying, right? So just being annoying, lack of evidence that anyone left the tavern. Okay, so being annoying is not disorderly conduct. As such, after the general trend of the cases has been, what is the general trend? For the courts to give narrow construction to the offense of disorderly conduct. Corey, do you have any insight into what this means for people who maybe aren't familiar with this legal terminology? What does this mean, narrow construction to the offense of disorderly conduct?
I mean, as opposed to where, in all of these cases, I mean, the ones that they're overturning convictions, they're taking this vague statute and trying to apply it, in various circumstances. And then that's why I said, it's disorderly conduct until the appellate court says it's not.
Can you hear me? Sorry, my headphone just died.
Oh, no. Yeah, I can hear you.
There's no echo or anything?
Mm-mm.
Okay. So, yeah, on appeal, the appellate court obviously doesn't have share the same view as, these lower courts and the prosecution, and they give it a narrow construction. It's, it's certain objectively unreasonable conduct. That's disorderly conduct. And anything that's outside of that narrow zone is not disorderly conduct.
So like we've said earlier, it's kind of scary because this is like a vague law. It could be used in any way, right? I mean, oh, she was alarmed and disturbed that you passed by her door. Now you're a criminal. But what this is saying is no. Generally, the cases have not done that. Maybe it is a broad law and maybe they do arrest people for it. But generally, when the courts decide on it, it's not just any old, every old thing. They have to really be rising to the level of, like you said, unreasonable and other stuff. When the conduct, so now they give us a little bit of an outline here. When the conduct of a patron of a private establishment, which Sean was not in a private establishment, which would probably have a little bit of a different threshold, what's disorderly in a private versus public, I would assume has a different threshold. So this is private. So even if you're at somebody's private establishment, merely annoying people, and the patron refuses the demand of the proper and refusing to leave, just being annoying and not leaving.
So I think
it is proper. So it does rise to it.
No,
Go ahead, Sean.
What they're trying to, what we're trying to say here is that, if you are engaged in, behavior that doesn't meet the standard of disorderly conduct, but you're in a private place, like annoying, being annoying or something of that, like in this case, being annoying to customers, the charge wouldn't be disorderly conduct. The charge would be trespassing if you're told to leave and you don't leave. So that would be the appropriate charge. And again, if they were in a private setting, it's different because, the owner of the private business or land has exclusive, rights to say you need to leave for whatever reason, right?
Because they own it, right?
Exactly. But in public, it's a little murky because how can you trespass somebody from someplace that they're supposed to be when they're not doing anything that's, criminal? That's not. How can you say you can just, because that's a slippery slope again. Can you do it? I've been arrested for criminal trespassing, apparently, but in a public place. But yes, they can do it. But but it's a slippery slope in the legal sense, because then if I'm somebody that, let's say I'm a person that likes for government transparency and about my specific town, and I'm, always going there for FOIA requests, and the mayor doesn't like me there, and he's in charge of that building, right? He's given custodial, charge of the building, and he just arbitrarily says you need to leave, and then if I don't leave, he has me arrested for criminal trespassing. What was the basis of the order to leave? Like,
Mm-hmm.
you're acting a fool in a public building and you're told to leave. Okay, I can understand that. But if you're just engaging in a constitutionally protected activity, conducting, lawful business, how could someone arbitrarily just, criminally trespass you from that building?
I mean, that's your Danbury case right there, right?
Exactly. Yeah. That's my
trespass charge. Wasn't it trespass in Waterbury as well?
Yes, that was trespassing in the post office. It was dismissed for they didn't have subject matter jurisdiction in that case. But
so what this argument is, and what you guys have laid out here is, okay, let's say you're in a private place and you're being annoying, you're refusing to leave, all that. In that case, as the precedent has been set, they should have been charged with trespass, not disorderly conduct. So that's what you're saying here. So if you're doing that in private, it should be trespass, but we're not even talking about that. So that's not our case here. Am I understanding that correctly?
Exactly. I think we just put it in there to show that even if Ruth was alarmed, she just asked to leave. She would have asked me to leave, and I didn't leave. It would have been trespassing, it wouldn't have been never. It's just to prove that my actions weren't disorderly conduct.
The existence of that offense affords protection of both. Okay. So then you go back to Bergeson. A defendant was convicted of disorderly conduct for allegedly looking into a neighbor's apartment window. Oh, God.
Yeah.
And so someone looked into his neighbor's apartment building and was arrested for disorderly conduct. And that was convicted as well. And then that was reversed. The appeals court said the following in that reversal. The most troubling aspect of this case is the defendant was a resident of the same apartment complex and was seen in a common area of the complex. The defendant was where he had a right to be. But moreover, since he was not charged under this specific section, the state was not required to even prove that the defendant had a lewd or unlawful purpose. The only requirement is that the conduct was unreasonable. And then the court said, there's nothing unreasonable about looking from 10 feet away at a window, which is completely covered except for a crack, while standing in a common area. So this guy was in a common area and he was accused of disorderly conduct and actually convicted of disorderly conduct because he was looking in the direction of someone's window in the apartment complex.
He's a peeping Tom.
At.
Yeah.
Go ahead.
He's a peeping Tom.
But why didn't he get charged with that instead of disorderly?
Well, I mean, yeah, I guess like that it could have been voyeurism or something like that. But I mean, that's just the court saying that even that doesn't rise to the level of disorderly conduct.
Right. And I always say, like, if there's this big broad statute, but there's a more specific one that would cover your actions and they weren't charged with that one, I'm suspicious, right? Like, a peeping Tom, like, usually has like some statute called something, right? Voyeurism or something, right? Invasion of privacy. There's something usually where it's like, if that doesn't apply, then you're going to jump to disorderly conduct. And that's basically what happened in Sean's case. Eavesdropping didn't apply, so they jumped to disorderly conduct. And it's like, okay, well, clearly, again, don't look in people's windows just in general, y'all. That is creepy. But I mean, it's not disorderly conduct, strictly speaking. Okay. According to the misdemeanor complaint signed by city administrator Ruth Siaba Green, Sean allegedly used a device to record conversations. This is what Ruth is saying Sean did. Use a device to record conversation between City Hall employees and Berwyn residents without their consent after being verbally advised. What? I like how they use this. They had to say verbally advised because they couldn't say commanded. Like, what? They're basically like, okay, you didn't follow our advice, so you're a criminal, right? Alarming City Hall employees. As an initial matter, this complaint is fatally flawed. Go ahead, Sean.
No, I was just saying, like, I kept saying they kept adding something at the end of it. That's what they said, thus alarming. So they wrote the whole complaint as if to charge him with eavesdropping, and then they said, thus alarming City Hall employees, and that's the sort of conduct.
They even put the ... Corey. ... Like they did, like they had to finish their thought because they had already had this written. And they're like, thus, they could have removed those ellipses and made it a little bit less obvious, huh? As an initial matter, so y'all see what Corey's saying? Like, it's almost like, okay, here's all this stuff. Oh no, this is not. They didn't put those dots, right? Y'all put it in there. Thus alarming City Hall employees. But like Corey said, y'all see this? Like, okay, all this other stuff, like about eavesdropping, oh, we got to get the language of the disorderly conduct in there. Let's squeeze it in real quick at the end. And it's like, okay, now he's disorderly. No, not quite. As an initial matter, their complaint is fatally flawed. Why is it flawed? Because it fails to accuse Mr. Reyes of engaging in any conduct which could conceivably be described as disorderly. We've discussed that ad nauseum here. We all agree on that one. Recognizing that a charging instrument is merely, okay, again, you can't just throw on the words that exist in the statute and all of a sudden it's, you're a criminal. At best, such allegations are consistent with eavesdropping, although, and they're going to smack them down with a Supreme Court case, the Supreme Court already struck down the state's eavesdropping statute as unconstitutional. This is huge, y'all. They were relying on a statute that the Illinois Supreme Court already struck down as unconstitutional in 2014 in People versus Clark. Notwithstanding, People versus Clark and People versus Malongo, which were issued simultaneously. Thank you, Universal Love, for the super chat. Notwithstanding, merely accusing Mr. Reyes of engaging in conduct which happened to alarm others is not sufficient to charge him with the offense of disorderly conduct. Charge him even, much less convict him. To be sufficient, the complaint must allege that Mr. Reyes knowingly acted so unreasonably as to provoke a breach of the peace. And again, I mean, they are alleging that. They're trying to allege that, but we don't really know what a breach of the peace really is. But y'all have established in this filing so far plenty of case law which would say that what you did was not a breach of the peace and was not disorderly conduct because it didn't breach the peace. Okay, Bradshaw said, okay, Mr. Reyes did not threaten, right? Remember, it was important whether he threatened someone. Obviously, he didn't threaten. We all saw the video, or otherwise directly disturb anybody. Although it could be argued, like in the case of Morris, a crowd gathered around Mr. Reyes. In stark contrast to the circumstances before the court in the case, this crowd was completely composed of Berwyn City police officers, opposed to an unruly crowd. Okay, so give us a little bit of insight into this case and why this is important, Sean, the crowd situation.
I think what I was trying to just illustrate here was that basically trying to preempt their arguments that maybe that I drew a crowd, but in this scenario, it's not like I drew a crowd of unruly people. I drew a crowd of police officers that I didn't want to be there anyway.
Right. It was a crowd of people that were already in the building.
Yeah.
And they were just coming to be nosy. They were coming to eavesdrop as far as I could tell. No, I'm just kidding.
Because I think in this case, I think what it says is that you can, if I'm not mistaken, is that by drawing that crowd of picketers for the undisputable evidence, that you can, Corey, I don't know if you're familiar with this case, but 50 picketers and further disputable video evidence. Basically, that I didn't draw a crowd intentionally or of violent people or anything like that.
Yeah, you're basically saying if they try to argue something about a crowd, it was all these people that already work in this building, and I didn't ask them to come over here, and I wasn't even talking to them.
I think you addressed that case earlier in the memo. I think that may have been the one about the argument, and it said that an argument with police officers isn't disorderly conduct.
Yeah.
Oh, good. I like that case. Okay. Okay. So, yeah. Okay. So then you just wrap it up, right? You obeyed affirmative orders not to leave.
And then the last part here is just all this last part is that it's by now we're getting into the unconstitutionality of charging somebody for a constitutionally protected activity. The First Amendment, Congress shall make no law abridging the freedom of free speech or press. So basically saying that just because being engaged in a constitutionally protected activity cannot in and of itself be turned into a crime.
Yes, I agree. Okay. So let's wrap this up because I want to get into this, what the state said to this. State's disorderly conduct statute is unconstitutional. Oh, that's what you just said, right? Okay. So what Sean just described this last part, right? Yeah. Mm-hmm. Okay. So let's get into the state's response to this. How long is it? Oh, shoot.
No, it's not long at all.
Okay. Okay. So Corey, do you want to walk us through this one?
I've never read it, so.
Oh, good. Okay. Let's go together on it. So the People versus Sean.
2 pages.
Huh?
It's only 2 pages?
1, 2, 3, 4.
I thought I only saw 3.
5.
Yeah, but that's like 2 pages of content right there.
Yeah, it's not very long. Double space, just 1.5 space.
It's not good at all.
That is unbelievable. You cited ample case law, and here they come with this. Let's see what they said.
Okay, let's see what they said. After so they describe you showing up, entering the hall, and video recorded his interactions with multiple staff members within City Hall. Those recorded include employees and customers of City Hall. The latter present on personal business of private concern and persons having some private phone conversations. The city notified police about defendant recording. Well, not really. I mean, Monaco was the one who was there, right? Maybe she did call the police. I don't know. And it was frightening. It was frightening and potentially violating the posted signage. Okay, Corey, so you've mentioned this, right? A lot. And I agree with you now. Like, why do they keep talking about these signs that they like embarrassingly had to tear down off of the front of the City Hall?
I really don't even know why they had to tear it down. I mean, they were obviously applying it in the wrong context, but something that I wasn't aware of was that the legislature in Illinois actually did reenact another eavesdropping statute. So it was struck down as unconstitutional as it was written before, but there is a new eavesdropping statute. But it doesn't apply to, recording in public. It applies to recording private conversations, and that gets into the whole reasonable expectation of privacy.
Well, I did a little bit of Googling, and it looks like Illinois is not the only state that is attempting to use eavesdropping statutes to keep people from being able to engage in this type of constitutionally protected activity. I mean, I read that there's other states that are doing this. So, I mean, maybe it's just intentional, right? They're trying to figure out some way to say you can't record in a city hall and use any old law. But I mean, why do they keep referring to the eavesdropping signs? This is not an eavesdropping complaint.
Yeah, even they admitted that when they said it doesn't apply. So that's, it's very curious to say the least.
So an unenforceable sign being posted, which could have literally said no recording in public if you're a woman, which we all agree would be unconstitutional. No recording in public if you're a man would be unconstitutional. So
it wasn't that long ago where there were signs posted that said no blacks, I mean, it was.
And that was struck down, right? I mean, as unconstitutional or at least reversed.
Struck down because people challenged it.
Yeah. Oh, yeah. Well, here we are to challenge. Okay. So the city administrator, that's Ruth, notified police, frightening, whatever. Okay. Prohibiting the use, and then they cite it, right? Prohibiting the use of any device capable of being used to hear or record oral conversation. And this is scary too. Like most of us have our phones with us at all times. We're always carrying a device capable of recording whatever, blah, blah, right?
Which are constantly recording us, by the way.
Yeah, true.
Yeah.
Hey, CIA. Oops, well, how you doing? Oh my God. Literally, my dang Siri came on. Okay. The defendant was ultimately detained pending investigation of the potential Oh my God. Corey, you're the one who said he wasn't. It was like they should have said arrested here, right? The defendant was ultimately detained pending investigation.
You can't bring someone into police custody and say that they're not under arrest. That's not an investigative detention. That's an arrest.
So again, they're just like using words that don't actually apply to the situation and pretending like that's the truth.
Makes it sound lighter, I guess.
Because they didn't read him as rights, right? The defendant was ultimately detained pending investigation of the potential statute violation and was charged with 1 count of disorderly conduct, a Class C misdemeanor, which Sean has already said is like the lowest level offense. It's just they're just trying to throw anything at him at this point.
Isn't it amazing that the whole state attorney's office in Berwyn they're that invested in this Class C misdemeanor that they're gonna attempt? Like, what is going on?
Yeah.
Right? And Sean, how many people were in court the other day from the state's attorney's office?
Yeah, like 6 or 7 state's attorneys were actually, my lawyer told me, were actually in the courtroom. There was actually a lot of people there supporting me as well. I didn't know. I was there via Zoom. My attorney was talking with them after the hearing. So if you were there, appreciate you. But there were six or 7, I believe you told me, state's attorneys in the courtroom just watching the arguments. And, somebody had told me that because first of all, obviously they're interested in this case, right? So they're interested in the case. Or somebody also told me that they could be, another way to look at it is they're trying to pressure the judge by showing a sign of, a sign of force. Like, we're all here watching this. Like, we know, we care about this case. We don't want it to be dismissed, and we're banding together. But yeah, it's very weird, especially in Crook County, where there's murders every day, and robberies and gang shootings, and Kim Fox is the same state's attorney. My lawyer told me, because this is where he works, so this is where he practices his law. She's the same state's attorney that not only just declined to prosecute the Jussie Smollett case, but she also declines to prosecute a lot of shooting cases where she'll put it up to mutual combat. So mutual combat, like, for example, my lawyer told me that there's like these gangs fighting in Chicago and they're shooting each other, and she declined to do anything about it because it's mutual combat. Mutual combat is a defense at trial. It's not a reason not to pursue the law. You can't just shoot people, or somebody. Even this case where he had told me that these two gentlemen were, I don't know if they're gentlemen, but these two guys were having a fight, and one guy tried to get away from him over a girl, and he went to his house, and he followed him all the way to his house, and he went to his driveway, and they got into a fight, and he ended up stabbing him or shooting him, the guy in his own driveway. She didn't press charges on the guy that stabbed or shot this guy because she said it was mutual combat. Again, I think it's basically the fact that she doesn't want to. From my understanding, it is well known that in Cook County, that the judges don't find probable cause at these probable cause hearings. They won't find probable cause on stupid charges like drug charges, on minor drug charges, just to not bog down the system, because there's so much crime and rampant crime in Cook County that they're just like, this is not worth it. No probable cause here, and they just, so that way it doesn't clog up the system of the dockets and stuff. So
there's an important distinction between declining to prosecute and then not pros, which is like revoking the charges after they've already the reason that they won't do that is because they are opening themselves up for a malicious prosecution charge, which they're already opening themselves up for regardless once this turns out in your favor. But it has to turn out in your favor for a malicious prosecution charge to be applicable.
I'm glad we're going to trial, because it will be recorded. Because normally, a criminal proceeding, you need the judge's permission, but normally the criminal proceedings aren't recorded because the defendant in the case normally doesn't want it to be recorded for privacy reasons or whatever. I actually going to petition the court for it to be recorded, and we'll be recording it and hopefully broadcasting it on the Young Turks, wherever else. So that way everybody could see it, and they could see Ruth Siaba Green, and they could see her melt on the stand, and I could be acquitted of these charges, and then the lawsuit will come right after that.
Are you planning on going to Illinois for the trial?
I have to.
You have to. I didn't know if they still had.
You can't.
Maybe I'll be there too, covering the case live.
You can't do you can't do a hybrid hearing. They don't have hybrid hearings for trials, but they will. It's going to be a bench trial, and like I said, it probably is going to be in July, according to my lawyer, and sometime in July, and hopefully we can get some news outlets to cover it. It's definitely,
hopefully we can get a little bit of a supporting rally out there going for you, some posters.
Yeah, we almost crashed the Zoom the other day in court, so
that's funny. And they only let 300 people in.
Yeah, exactly.
I wonder if that was the most people that have ever been trying to look at a case on that server.
Probably.
So let's see what else is going on here. Okay, so
they're doing eavesdropping again?
Go ahead, what?
No, I just saw the first sentence of the argument portion where they said something about eavesdropping again.
Oh, let's see. Where were we though? Were we down there already? Oh yeah, look, any argument that the complaining witness's reaction to defendant's actions was exaggerated or feigned, which you didn't make that argument, did you?
No. It's irrelevant whether
what does this have to do with anything?
It's irrelevant if she was feigning her fright, her being, or exaggerating her alarm, or that's all irrelevant. And this is why it's like, Alyssa, what are you doing here? Because it doesn't make any sense. I don't care if she was really alarmed or she wasn't. My personal opinion is she wasn't. But even if she was, it doesn't matter. It doesn't matter at all.
My personal opinion is she wasn't.
Exactly.
But I'm aggravated they put this in here. Any argument that Ruth's reaction to your actions was exaggerated or fake. What the hell? This didn't even need to be in here. So your contention is that an opinion? What? I feel like I'm being gaslit. It's neither fact nor law. The court has held that whether an act provokes a breach of the peace depends upon all. Oh man, I've seen legal writing class turn in, essays better than this. Breach of the peace implies that you engaged in conduct that created a consternation and alarm. So you created a breach of the peace is their argument. But how does this connect to this? Any argument that they were faking it gives more weight to your opinion. You didn't say anything about her faking it. This is like a useless paragraph.
Yeah, I guess she had to use some filler in her argument.
Yeah, because she didn't want to actually turn in 2 pages, probably. This is embarrassing. It's not too late for you to turn the right direction, Alyssa, because this is a bad path you're going down, honey. Bless your heart. Okay. So I don't know what the point of that paragraph was. Didn't make no sense to me. So we're going to move on. Okay. Here's their argument. Corey, yes, they have used the eavesdropping statute.
Again.
Why would they include the eavesdropping statute after they didn't even... Okay. Regardless of whether it's constitutional or not, let's suspend that for 1 second. You are not being charged with eavesdropping. And you argued this to the court, right? And now they still came back and said, but the eavesdropping statute says do. So, Corey, your opinion seems to be they already had this thing written up, ready to charge him with eavesdropping. Then somebody with half of an ounce of sense said, y'all can't do that. It's going to fail. Best chance is disorderly conduct. But then they couldn't really make that argument. So they're, like Sean said, fluffing up all the extras in the paper to try in the filing to make it look like Sean did all this bad stuff. But really, he's not even being charged with that. So why is it in here?
I don't know, because we're also talking about a public establishment. So the whole private communication things goes out the window.
I don't get it. Okay. Examining the circumstances surrounding your arrest when you entered and remained in City Hall, which is occupied by both employees and civilians, using a camera for both video. So I've seen a lot of people, I want to stop for just a second. I've seen a lot of people, not a lot, a handful, a few people saying like that this is going to be like a precedential case and it's going to go all the way up to the Supreme Court and stuff like that. I definitely think a case like this will go to the Supreme Court. I do think that it will ultimately have to be decided by the Supreme Court of the United States, like what exactly, like the recording or First Amendment, public, whatever. But this ain't going to be the case that gets there because it's not well pleaded. It has nothing to do with the arguments that actually need to be made to try and incite some type of change. Do you agree, Corey?
This won't even get past the Illinois Appellate Court.
I don't think so.
It shouldn't get past the trial court, but I mean, I don't have too much faith in her. So
they're embarrassing over there. Well, maybe it's not going to be her, right? It could be a different lawyer, a different judge.
And just remember that what we're reading here, a sitting judge read, who they're supposed to know the law, they're supposed to know the Constitution, also took oaths to uphold the Constitution of the United States. And she read this garbage and decided to deny my motion.
You know what that is probably about, though? A lot of the time, judges really just don't want to write opinions, so it's just easier for them to deny the motion. Because if she granted the motion, she'd have to write an opinion, justifying it, and it would go up an appeal there. So I guess she's buying herself some time, or maybe it'll be a different judge who has to deal with it. So we'll see.
That's possible. That is possible as well. I personally don't want to write an opinion, so that would make sense. But it's also not my job to write opinions. If it's your job to write opinions, you should write opinions. I just want to be clear on that. Okay, so they cite the eavesdropping statute for what reason, I don't really know. Probably because they already had it written and had to change it. Examining the circumstances, okay, occupied, and okay. You were using a camera for both video and, importantly, audio. So they make a big deal about this audio crap. Your motion to dismiss argues that your actions should be of no consequence to the complaining witness because they are regularly recorded by security cameras and thus consent to being recorded on a daily basis. His actions should be of no consequence because they are regularly recorded by security cameras. Oh, so they're making an audio distinction. They're saying these people are videoed all the time, but it's just video.
It's not audio.
Okay, so what's the argument here? This is them. Okay. Yeah. This defense motion argues, okay, the Illinois State Supreme Court establish, now this is the state saying this, that consent may be satisfied without showing any type of informed consent necessary for a offendant. Wait. Oh, so they're saying she didn't give her consent. So because she didn't give her consent, that you were, because she didn't give her consent and you were audio recording her, that you were eavesdropping, even though you're not being charged with eavesdropping. So we're still talking about eavesdropping. I feel like I'm on mind altering substances.
Did I not tell you that when you read this, you would lose some brain cells?
You literally said that. I literally feel that way. I feel like I'm on mind altering substances right now, and I am not.
Doesn't make sense.
I'm glad there's another lawyer here to confirm, because I feel like I'm being gaslit right now. Okay, so she didn't consent, and Sean violated the eavesdropping statute, which he's not being charged with. Okay, so far, Sean, like, if you weren't on here, what I would say right now is I agree with your argument, and I don't agree with their argument, like, fully. Like, I don't understand why they keep talking about eavesdropping when that's not what you're charged with. In the case here, there have been no facts presented to indicate that either that either Ruth or any employees of City Hall or the private citizens expressly consented to be recorded.
Eavesdropping again.
Are you seeing this, Corey?
Are they going to get to the point where they talk about a breach of the peace or
disorderly conduct? Yeah, nothing. And that's what the judge is saying. Like the judge is trying to say, like, there's no. I need to know the facts. Don't you think the state would have provided some sort of facts if they wanted to keep the case going? It just, I don't understand it, to be honest with you.
I hate this. They paid taxpayer money went to write this garbage.
She sat at home writing this.
No, she sat in a taxpayer-funded building writing this.
In her little cubicle.
On a taxpayer-funded computer.
Yeah,
I hate when it's not
with taxpayer-funded internet. Okay.
It's just irrelevant. This whole part is just irrelevant again.
It's completely irrelevant. Okay. Moreover, establish actions police officers. Defendant was not detained or charged with unlawfully recording police officers. So, what does that have to do with anything? Rather, go ahead.
She's talking about police officers, but the case law says public officials. It doesn't say police officers.
This one, Glick and Justice?
Yeah, police officers. I mean, public officials. Excuse me.
Those are federal appellate decisions.
As the language of the complaint outlines, you were cited for recording conversations occurring between City Hall employees and private citizens, which you did not do. Also, let's say you were being charged with eavesdropping. We need to reestablish here you didn't do this.
No.
She came up to you, and then you were having an interaction with her, and she was immediately aware that she was being recorded, because her first question is, are you recording me? So it wasn't a secret to her. So it's not eavesdropping. So
and the only private citizen who he recorded actually consented to being recorded, or at least said he didn't care.
That's a good point.
Check it out. In the state of Illinois, absent the consent of all parties to a conversation, one cannot lawfully audio or video record a conversation. This is she literally this is just the eavesdropping. I don't get it. I don't get it.
Sean, where did they talk about your disorderly conduct? Where did they talk about alarm? They didn't even use the alarm or the breach of the peace.
No, they were saying because I didn't get their permission, that caused alarm. They said that, but because I didn't get their permission, that caused an alarm.
Corey,
they didn't even use that phrasing in there. I didn't see anything about an alarm. She's strictly arguing eavesdropping here. They need to amend these charges or something.
Yeah, no, but I'm not even exactly. I'm not being charged with eavesdropping, but that's all they're. And my lawyer was. I had like an 2-hour-long conversation with my lawyer after this hearing, and he's like, they're just arguing the eavesdropping statute, and they didn't even charge you with it. And it's like, you would lose that. You would lose that too. I'm not opposed. Go ahead, bring me up on eavesdropping. I don't care, but it doesn't matter. You would lose both arguments, but you just look stupid arguing eavesdropping.
At least argue the breach of the peace. Put forth some. I mean,
yeah, but they can't, because normally what police officers will do, and this is why it's very important. Everybody who's watching this right now, and I tell this on my channel all the time. You record every interaction you have with police officers. Every single one, whether they're helping you, whatever it is, you record it, because they will turn. If I wasn't recording, imagine what they would have said. I was following people. I was stalking them. I was, going into offices. They would have made up but they can't. So they just keep going back to this eavesdropping thing. And it's like, because they know that there's a video. So like, we can't really say he did anything disorderly because he didn't. So
how many views does the video have?
About like 400,000, I think.
Oh, good. They need to drop these charges. This is so embarrassing. I am embarrassed for them.
Yeah.
Okay. So basically they go through this whole entire thing. They never say that you were disorderly, really. Okay. So the interaction, here's the conclusion. Here's their conclusion. They're hanging their hat on this paragraph, y'all. Here we go. The interaction between Sean and all persons present at the city hall was recorded without prior consent, either express or implied. It's so cute how they throw it in how they threw in express or implied, Corey. Like, we think this is something legal jargon, something express or implied. Just throw it in there. Just sprinkle it on there like a seasoning.
It is implied because it is. But even if we're still arguing eavesdropping, but even if it was implied, you know why it's implied? Because there's no expectation of privacy in public.
It's called the First Amendment, folks.
She should understand this. There's no expectation of privacy in public. This is why
I really take for granted. I don't know about you two. Like, I don't know if y'all always just knew about the law and your rights. I didn't. I really didn't learn about it till I went to law school. And so now I kind of take for granted, like, what I think is common knowledge is just not. And it's like, every time I hear somebody tell you it's illegal to record in a federal building, I'm like, shouldn't you know that it is not illegal? But they don't know. They have no idea.
Yeah.
And they say it all day, and people listen to them. Oh, it is. Oh, let me put my phone up. Okay. These parties to what? It would need to be a party to a conversation or an interaction. So I don't understand. Like, the people you just like randomly caught in the video were not parties to anything. Included City Hall employees as well as private citizens who were either physically inside the building or calling on the phone. Oh, girl. You are kidding me. You might have heard them picking up a phone conversation. Is that what they're saying right here?
Yeah, even the people on the phone.
Alyssa, girl. When evaluating these circumstances, a trier of fact should find that the reactions of the people being recorded were appropriate to feel threatened and frightened by Sean when he refused to stop recording after being repeated. She was so threatened and frightened, y'all. She walked slowly to her desk and sat back down, left her door open, and kept going about her day. That's how threatened and frightened she was. For these reasons, the state requests the court to deny defendant's motion to. I'm more mad now after reading this. Corey, what are your thoughts? What are your takeaways from this?
I'm blown, honestly, because this is my first time going over it. I thought that they'd at least put forth some kind of an argument arguing that he breached the peace or was otherwise disorderly. She literally exclusively argued eavesdropping, and he's not even being charged with it. I honestly can't even wrap my mind around it.
I'm mad. I'm just mad. I've already told y'all my thoughts on it.
Very entertaining.
But it would be really entertaining if it was happening to someone I didn't like.
Yeah.
Support, like it wasn't happening to my friend. I would be like, haha, this is so funny. I hope that person gets justice. But like, I'm like, no, hold on. I'm mad. I'm actually mad because like you said, they didn't even really try to tack on the alarm disturb. It's just this should be used as an example in law school writing class as to like what to not do. Like, here's a bad example of a brief and it's real. And it's like now thousands of people have seen it.
Yeah. Hundreds of thousands of people. And it's there forever, Alyssa. You put your name on it. You signed the bottom of it.
Respectfully,
Alyssa Dunbar.
Hold on. Let me pick it up. Let me hold on. Respectfully lying.
Respectfully, Alyssa Dunbar.
Respectfully doesn't know what she's talking about.
I don't know.
With all due respect, you are clueless, girl.
Really? I mean, there's no nice way to go about it. And I don't doubt, I really don't doubt her intelligence. I don't. I don't doubt her intelligence. I said this in the live. I'm not doubting your intelligence, Alyssa. I'm doubting your morals.
Integrity.
I think in your integrity, exactly. Your morals and your integrity. That's what's in doubt here, because I think you wrote this bullshit document that you knew is bullshit, and because there's no way you believe anything you just wrote.
But how come she didn't even address any of the case law that you cited? Like literally none of it. Not even not the constitutional argument, none of the case law.
So explain, Corey, what it would typically look like. What you're, for people who are not aware, usually in a state's response to someone's motion to dismiss, where they have outlined case after case after case, what would usually happen, and why? Explain why you're surprised.
She in conclusory fashion said. It was Glick, and I forget the name of the other case, but it was about the public recording of officers. She said that it's distinguishable, and then didn't really explain why the cases were distinguishable, other than saying that it dealt with cops, which is true. Those cases did deal with recording cops, but the language that Sean already talked about was talking about recording public officials in the course of their official duties.
So normally, like you said, she would have really gone in. You were surprised to see it was only 4 pages, right? Because Sean had all this case law where he said, look, here's all the laws that apply to me, our cases. Here's all the cases that say that this law would never even apply to me. All of this thought, all of this stuff. And she did 4 pages on the eavesdropping statute.
This has just got to be a case of the judge not wanting to write an opinion, because after seeing this, I mean, what was that?
I think I would like to go to the court hearing myself and just report on this in July.
I would love to join you. That would be, that'd be great.
4 pages of this. Well, we have all been on live for what's coming up on 3 or 4 hours. So I'm going to say I'm tired. It's been really nice to do this, and I definitely want to do more collabs. Corey, friend of the channel, if you want to come back on here, have some opinions on things. I know, Sean, I'm definitely looking forward to continuing to cover this case and keeping in touch with you as it goes on. Is there anything else that y'all want to say to conclude our 2-part series before we wrap it up for the night? If anybody has any questions, we'll take a couple, but I'm tired, so hurry up. No, I'm just kidding.
I just want to say thanks for having me. It's been a pleasure.
Thank you, King T. Thank you for coming on, Corey. I'm really always heartened to have lawyers come on who seem to have any respect for the oath that we took. So I'm so happy that I met you, and we need to all keep meeting each other, because this is all of us against tyranny and corruption. So I'm here for the fight.
Exactly. No, and again, thanks for having me. Thanks for coming on earlier. And also, I appreciate both of you guys for, honoring your oath to the Constitution. I didn't take one, but I believe in it. And I believe in there's people like you guys out there. I get emails all the time. So for those that, I can't answer every single email, but I get emails from patriots and like-minded folk like us who believe in the Constitution and our rights and freedom. And I appreciate each and every one of you out there. I appreciate you too so much. Corey, you're a brother to me. BJ, thank you for having me. I really appreciate it.
Of course. And everyone, do follow Sean's channel. He is the best auditor that I've come across on YouTube, and one of my favorite YouTubers, period. And like I said, I watch his videos more than anyone else's. It's very empowering to see someone do what he does, and it's not easy at all. So thank you for the work you do, putting quite literally your freedom on the line to protect our rights. And people like me and Corey will be around, and we'll be using whatever, power that we have and sounding the alarm, because we're going to just be doing this until it stops, which is probably going to be never. So facts ain't defamation. I'll talk to y'all later. And thanks again, guys, for being here. Everybody have a great night. Go follow, go like, go subscribe. Talk to y'all later. Facts ain't defamation. Love you, mean it. Okay, bye.